Y'all. 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 Pull your phone closer, because what I am about to read to you off these federal court documents is going to make Tasha K's stomach drop straight through the floor of whatever Airbnb she's hiding in tonight. I'm not talking gossip. I'm not talking blogs. I'm talking signed, stamped, filed, ink-still wet federal paperwork that just hit a judge's desk, and baby, if half of what is in here lands the way Cardi B's lawyers want it to land, Tasha K will literally wake up one morning and not own the bed she is sleeping in. Not the bed. Not the sheets. Not the lash glue on her vanity. Nothing. Because everything she touches, everything she earns, everything she breathes on financially, will belong to Cardi B until that $7 million number is satisfied to the last red cent. And before any of you scroll, before any of you say, Tisa, you're being dramatic again, I need you to understand something. I have read these documents 3 times. I read them once for shock. I read them twice for receipts. I read them a 3rd time just to make sure I was not hallucinating, because what is in here reads less like a civil filing and more like a hostage negotiation with the federal government holding the gun. So sit down. Lock in. Put the dishes in the sink for 10 more minutes. Because we are not just talking about money anymore. We are talking about a woman's entire future income stream being legally rerouted into the bank account of the person she spent years trying to destroy. And the wildest part? She did it to herself. With her own husband. On the record. Under oath. With a judge who literally warned them not to. Let me set the table for you, because there is a backstory here that even some of the bigger blogs are skipping over, and I refuse to let you sound dumb in the comments section of somebody else's video. The original number Tasha K personally owed Cardi B was $3.8 million. That was her personal slice of the judgment. But people keep forgetting there was a second defendant. KBI Studios. That was the business entity that produced the content that got everybody sued in the first place. KBI Studios got hit with a separate slice of the judgment, and when you add Tasha's personal portion and the company's portion together, you are now staring down a combined liability of roughly $6.5 to $7 million. Not 3. Not 4. Almost 7. And that is the number that has been quietly compounding in the background while Tasha K was on Instagram pretending to count Molly money and tagging palm trees like the IRS doesn't have Google Earth. $7 million. Say it out loud. Let it rattle around in your skull. That is the number that triggered the move that Cardi just made in federal court, and it is the number that explains why the response from the judge has been so unusually aggressive. Judges don't take this kind of swing unless somebody has been openly and brazenly playing in their face. And according to this filing, baby, Tasha K and her husband have been playing in the court's face for about 2 years straight. Here is where it gets surgical. According to the filing, on May 31, 2023, almost immediately after the jury verdict dropped, Tasha K's husband, the one being referred to in the docs, formed a brand new company called Yellen Entertainment LLC. New name. New shell. New paint job. Same exact car. The lawsuit lays out, in plain English a 5th grader could follow, that he then allegedly transferred the entire operating guts of KBI Studios, the revenue streams, the going concern value, the contracts, the talent services, the day-to-day business of Tasha K herself, over to this freshly minted Yellen Entertainment. And he did it for, and I quote the spirit of the filing here, no consideration. None. 0. Not a dollar. Not a peppercorn. Not a stick of gum. He did not pay KBI Studios for the business he was scooping out of it. He just lifted it, dropped it into the new company, and kept it moving like nobody was watching. And then, this is the part that made me clutch my chest, KBI Studios was dissolved. Wound down. Closed up. Turned into an empty corporate husk with no assets inside of it. So when Cardi B's lawyers came knocking on KBI Studios to collect the company's share of that judgment, the door opened to a room with no furniture in it. No money. No equipment. No ongoing business. Just a name on a piece of paper. Meanwhile, across the street, sitting in a brand new house, was Yellen Entertainment, doing the exact same work, with the exact same talent, generating the exact same revenue, but conveniently with a different LLC sticker on the front door. Y'all, this is not subtle. This is not creative tax planning. This is the legal version of a magic trick where the magician forgets to put the rabbit back in the hat and the rabbit is just sitting there on the table looking at the audience. Now let me explain to you in plain language what a valid business transfer looks like, because I have seen people in the comments confuse themselves trying to defend this, and I want to inoculate you against the dumb takes before they reach your timeline. For any transfer of assets, business interests, real estate, anything of real value, to be considered legally binding and respected by a court, 3 ingredients have to be in the bowl. 1. An offer. 2. Acceptance. 3. Consideration. Offer is, hey, I will give you this thing. Acceptance is, cool, I will take this thing. Consideration is the thing of value that the receiver gives back. It can be money. It can be stock. It can be a promise to perform services. It can be assumption of debt. But it has to be real. It has to be something. You cannot just slide a multi-million-dollar media operation from one company to another company you happen to control, write $0 on the receipt, and expect a federal judge to nod and say, looks good to me. That is not how this works. That has never been how this works. Now, there is a separate lane called the lifetime gift exemption, which allows a person to gift up to a certain amount, currently in the multi-million-dollar range over their lifetime, to family members tax-deferred, but, and this is the part nobody talks about, you have to declare it as a gift to the IRS using the proper forms. You cannot quietly slip a company under the table and call it a gift later when the bill collector shows up. The IRS has to know. The paperwork has to exist. The intent has to be documented at the time of transfer, not invented after the fact when a judgment creditor is standing on your porch with a writ. And from what the filing alleges, none of that proper documentation exists. Which means we are not looking at a gift. We are looking at what the law has a very specific, very unflattering name for. A fraudulent transfer. But hold on, because we are nowhere near the bottom of this pit yet. The filing goes on to lay out what is called a continuation theory. The legal argument is that Yellen Entertainment is not a new, independent company at all. It is the mere continuation of KBI Studios. Same owner influence. Same talent. Same business activities. Same revenue streams. Same management structure. Same customers. Same vendors. Same everything, just with a new name on the door. And the reason that legal theory matters is because if a court agrees that the new company is just a continuation of the old company, then the new company is on the hook for the old company's debts. Yellen would inherit the KBI judgment. Every dollar that flows into Yellen would become a dollar Cardi B can reach for. And once you stack the continuation theory on top of the fraudulent transfer theory, you are now staring down the legal mechanism known as piercing the corporate veil. And I need you to understand what veil piercing does, because this is the move that turns a contained business problem into a personal apocalypse. A corporation, in the eyes of the law, is treated as its own separate person. That is the whole point of forming one. You and your company are legally distinct. If the company owes money, the company pays. If you personally owe money, you pay. The wall between you and your LLC is what protects your house, your car, your savings, your kids' college funds from getting dragged into a lawsuit aimed at the business. That wall is the veil. But, and this is the but that should be tattooed on the inside of every business owner's eyelid, that wall is only standing as long as you respect it. If you mix personal and business funds. If you use the company as a piggy bank for personal expenses. If you fail to keep proper records. If you ignore corporate formalities. If you operate the company as a sham. Or, and this is the big one in our story tonight, if you set up the corporate structure for the explicit purpose of dodging a legal obligation, the court has the power to reach right through the wall, grab you by the collar, and treat the company's debts as your personal debts and your personal assets as collectible to satisfy the company's debts. The veil is gone. The shield is gone. The legal fiction collapses. You and the company become the same wallet. And once that happens to Tasha K and her husband, every bank account either of them touches, every car either of them drives, every property either of them owns is fair game. Now you might be asking, Tisa, what makes a judge actually willing to pierce a veil? Because judges don't do that lightly. They don't wake up looking for reasons to dismantle the corporate form. They need evidence. They need pattern. They need what lawyers call badges of fraud. And, my friends, this filing is dripping in badges. Plural. So many badges it looks like a Girl Scout sash designed by a con artist. Let me walk you through them one by one, because each one on its own is bad, and each one stacked on the next builds a case that even a sympathetic judge would have to take seriously. Badge number 1, timing. The new company was formed almost immediately after the jury verdict. Not 5 years before. Not during a normal business expansion. Not in response to growth. Within weeks of the verdict, the new entity was on file with the state. Courts noticed timing. Timing is loud. Timing screams intent. Badge number 2, no consideration. As we already broke down, the old company's entire business was scooped out and dropped into the new company without a single dollar paid in exchange. That is the textbook definition of a transfer made to hinder creditors. Badge number 3, same control. The new company is allegedly controlled by the husband, who, according to the filing, also effectively controlled the old company. Same person. Different LLC. Identical activity. Courts call this a continuation, and courts hate it. Badge number 4, dissolution of the predecessor. KBI Studios didn't just sit there empty. It was dissolved. Wound down. Closed. That step, combined with the asset stripping, is the legal equivalent of robbing a bank and then setting the bank on fire so investigators can't find your fingerprints. Badge number 5, the payroll rerouting. According to the filing, Tasha K's earnings were no longer flowing to her directly. Instead, the money was being routed through the new company in a way that, the documents allege, was specifically structured to make it harder for Cardi B's legal team to garnish her wages. Garnishment is the legal process where a court orders a portion of your paycheck to be redirected to the person you owe money to. If your money never officially hits your personal account, garnishment becomes harder. But, baby, courts can see through that little dance from a mile away. Especially when the husband allegedly admitted under oath, that is the part one want you to underline twice in your mental notebook, under oath, sworn testimony, on the record, that the reason these moves were made was specifically to frustrate Cardi B's ability to collect. He said it. With his own mouth. To a court reporter. There is a transcript. There is a recording. There is a stenographer who heard him say it and typed it up word for word. That admission alone, just that one sentence in his deposition, is the kind of thing that a plaintiff's attorney prints out, laminates, and frames above their desk. Because once you admit on the record that the purpose of a transaction was to dodge a creditor, that transaction is hanging by a thread. And the thread is on fire. Badge number 6, the house. Approximately 1 month after the original judgment, Tasha K allegedly transferred her interest in a Georgia property over to her husband. Free. No payment. No consideration. Just signed it over like she was passing him a dinner roll. Now, transferring property between spouses is not, by itself, illegal. People do it all the time for legitimate estate planning reasons, tax reasons, asset protection planning that is done years in advance of any litigation. But when you transfer a property 30 days after getting hit with a multi-million-dollar judgment, when the entire legal landscape around you is on fire, that timing is not estate planning. That timing is what your lawyer is going to call, in private, the worst thing you could have possibly done. Because a federal judge looks at a transfer like that and sees one thing. Intent to defraud. And intent to defraud is the magic phrase that unlocks every aggressive remedy in the creditor's toolbox. Badge number 7, the mystery brother. Y'all, I cannot make this up. According to the filing, when the husband was deposed and asked about the ownership structure of the new company, he testified that his brother, allegedly residing in Mali, Africa, owns 50% of Yellen Entertainment. 50%. That is half. That is a major ownership stake. But, and here is where the comedy of errors begins, Cardi B's lawyers pointed out that the husband's own tax returns reportedly show him as 100% owner. Not 50. 100. So either the tax returns are wrong, in which case there is an IRS problem, or the deposition testimony is wrong, in which case there is a perjury problem. There is no version of this story where both of those documents are accurate, and that is the kind of contradiction a federal judge will not let slide. On top of that, the filing notes that no evidence of the brothers' ownership has ever been produced. No operating agreement. No K-1 filings. No capital contributions documented. No proof that this brother has ever received a distribution. No proof that he has ever exercised ownership rights. He is, in the words of the filing, essentially a ghost. A name on a witness stand with no paper trail behind him. Which is exactly the kind of thing the IRS, on a slow Tuesday afternoon, decides to investigate just for fun. And remember those long stretches when Tasha K was posting from West Africa? The smiling photos, the food, the captions about peace and reinvention. In hindsight, with this filing in our hands, those posts look less like a vacation and more like a strategic geographic decision. Because, as I have been telling y'all for years, civil judgments at the state level are notoriously difficult to enforce overseas. American state courts don't have authority over foreign banks. You can win $1 billion verdict in a Georgia courtroom, and if the person you sued moves their assets to a jurisdiction that doesn't recognize American state judgments, you are basically holding a piece of paper that is worth slightly less than the paper itself. But, and this is why this new filing is so devastating, federal court is a completely different animal. Federal judgments carry significantly more weight in international enforcement actions, especially under treaties and reciprocal arrangements between the United States and other countries. Cardi B's team is not in state court anymore. They are in federal court. They are taking the gloves off, walking up the ladder, and stepping into a venue that has actual teeth in cross-border collections. Tasha K's overseas plans, if any existed, just got a lot more complicated. I also want to talk for a second about depositions, because some of y'all do not fully understand what happens inside that room, and once you do, you will see why the alleged admissions in this case are so devastating. A deposition is a sworn legal proceeding, usually held in a conference room, sometimes recorded on video, where attorneys for both sides get to ask a witness questions under oath. Every word is transcribed by a court reporter. Every pause. Every cough. Every, and I don't recall. The transcript becomes a permanent part of the legal record, and it can be used at trial, used in motions, and used to impeach the witness if they ever try to change their story later. Going into a deposition is like going into a permanent recording booth where every word you say can and will be played back to you for years to come. The smart move, the move every experienced litigator drills into their clients, is to answer questions narrowly, factually, and without volunteering extra information. The dumb move is to start explaining your reasoning. Because the moment you explain your reasoning, you start telling the lawyer on the other side why you did what you did, and reasoning is where intent lives, and intent is what unlocks the heavy remedies. According to this filing, the husband did the dumb move. He explained. He elaborated. He gave the reasoning. He told a court reporter that the asset moves were undertaken specifically to help his wife avoid garnishment. That is not a slip of the tongue. That is not a misunderstanding. That is the bullet that the other side picks up and loads into their gun for trial. And once it is on the record, you cannot put it back. Now let's talk about the part of the filing that has every legal commentator on Twitter losing their entire mind. The constructive trust. Okay. Sit down for this one. A constructive trust is one of the most aggressive remedies a court can impose in a fraud case. What it means, in plain English, is that the court takes everything the defendant currently owns, everything they currently earn, and everything they will own or earn in the future, and legally declares that those assets are no longer the defendant's property in any meaningful sense. The defendant is reduced to a custodian. A glorified employee. They hold the assets, but only on behalf of the creditor. Every dollar that comes in, every property that exists, every bank account, every revenue stream, every royalty check, every brand deal, every YouTube AdSense payment, every Patreon dollar, every speaking fee, every advance, every check from any source, is funneled directly into a trust, and the sole beneficiary of that trust is the person they owe money to. In this case, Cardi B, Tasha K would be allowed to keep enough to cover reasonable living expenses, the basics, food, shelter, utilities. Everything else, every penny above subsistence, flows out of her hands and into Cardi B's account until the $7 million debt is satisfied, with interest, in full. That is what a constructive trust does. It is the financial equivalent of being placed on a long, public, court-supervised diet, and the diet is just oatmeal and water until the bill is paid. Pause. Breathe. Let that fully marinate. Because what this means, if a judge grants it, is that Tasha K does not get to choose what she does with her own income anymore. She does not get to decide to take a vacation. She does not get to decide to launch a new venture. She does not get to splurge on a bag, a car, a renovation, a new piece of equipment for her studio, a flight, a hotel, a dinner above whatever the court considers reasonable. She becomes, in the most literal financial sense, an employee of Cardi B. A worker generating revenue, and the revenue belongs to somebody else by court order. Forever. Or at least until that $7 million number is gone. And given the kinds of expenses and lifestyle moves we have seen documented over the years, the idea of Tasha K paying down $7 million on a constructive trust budget is not a one-year project. It is not a 5-year project. We could be talking about a decade or more of court-supervised earnings. The math is brutal. The implications are even worse. And then we get to the cherry on top, the permanent injunction. The filing reportedly asks for an order that would prevent Tasha K and her husband from transferring, hiding, encumbering, or otherwise moving any assets while the case is pending. Not later. Not after the verdict. Now. From the moment the order is signed. That means no more sneaky transfers to brothers in Mali. No more refreshing the LLC paperwork at midnight on a Tuesday. No more flipping property deeds between spouses. No more quietly opening accounts in different jurisdictions. Every move involving an asset has to be visible, documented, and approved within the framework of the court's order. And if they violate it? Contempt of court. Which can include fines that pile up by the day, and yes, in serious enough cases, jail time. That is not theoretical. That is the standard remedy when a court order is being thumbed at by parties who have already been caught moving assets to dodge creditors. Judges don't play that game twice. Quick legal vocabulary lesson, because these phrases will keep popping up in the news and I want you to be the smart one in your group chat. When you hear the phrase fraudulent conveyance, what that legally means is the transfer of an asset from a debtor to a third party with the intent of preventing a creditor from being able to reach that asset. It does not necessarily require that the debtor be screaming, "I am committing fraud right now," at the moment of the transfer. Courts look at the surrounding circumstances. The timing. The relationship between the parties. The presence or absence of consideration. The retention of control over the asset after the transfer. The general atmosphere of, did this person know a creditor was about to come looking, and did they then move the thing the creditor was going to come looking for? If the answer is yes, the court can unwind the transfer. Reverse it. Treat it as if it never happened. And whatever was transferred goes right back into the pool of assets available to satisfy the judgment. That is what the law calls avoidance, and it is one of the most powerful tools in a creditor's arsenal. So when you hear that Cardi B's lawyers are pursuing avoidance of those transfers, you should mentally translate that to, they are asking the court to legally rewind time and put the assets back where they belonged before the alleged shuffle began. The next phrase you will hear is alter ego doctrine. That is a fancy legal way of saying, this company is not really a separate entity from the person running it. It is a costume. It is a mask. It is the person themselves, dressed up in corporate paperwork, walking around pretending to be a different legal being. When a court finds that a company is the alter ego of its owner, the protection that the corporate form would normally provide evaporates. The owner's personal assets become reachable for the company's debts, and the company's assets become reachable for the owner's personal debts. Everything blends. Everything becomes one pot. And once that finding is on the record, every creditor in line for either the person or the company suddenly has a much bigger menu to choose from. The filing in this case stitches together multiple alter ego arguments, and once you read them, it is hard to imagine a judge looking at this picture and concluding that Yellen Entertainment is a genuinely separate, arm's-length business operating without owner influence. It does not pass the smell test, and federal judges have famously sensitive noses. Now I want to circle back to the original restraining order, because some of you missed how brilliantly it was structured, and you need to understand it to see why this is checkmate. The restraining order didn't just say, Tasha K, you cannot talk about Cardi B. That would have been easy to work around. The order said, in effect, that Tasha K cannot talk about Cardi B, anyone Cardi B is in a relationship with, and anyone who is in a business association with Cardi B. Read that again. Slowly. Because what that language does is hand Cardi B a remote control with which she can expand the protected circle anytime she wants. Cardi could, in theory, sign a business arrangement with anyone, a hairstylist, an artist, a friend, a producer, an influencer, and once that person is publicly identified as a business associate, they fall under the umbrella of the restraining order. Tasha K then loses the ability to discuss them on her platform without risking a violation. And violations of restraining orders, especially after the first one or two, come with escalating consequences. Fines. Then bigger fines. Then potentially jail time. So while the rest of us are arguing about whether you can mention somebody whose name starts with the same letter, Cardi's legal team has essentially built a chessboard where she controls when and how the pieces appear. That is not gossip. That is architecture. That is somebody at the top of her game playing 4 moves ahead. And here is the human part of this story, because I refuse to do a video that is just paperwork without acknowledging the people inside the paperwork. Cardi B has been criticized for years for, in some people's view, being too emotional, too reactive, too quick to fire off on Instagram Live. People underestimated her. People wrote her off as a hot-headed celebrity who couldn't focus. But what we are watching now is what happens when somebody at her level steps back, lets the lawyers do the lawyer thing, and quietly builds a war chest while everybody else is busy posting screenshots. While Tasha was in Mali. While the blogs were arguing. While the husband was filing fresh LLC paperwork. Cardi's legal team was reading depositions, cross-referencing tax returns, mapping the asset transfers, and stacking up the badges of fraud one by one. This filing was not made in anger. This filing was made with the cold, methodical patience of a person who decided a long time ago that she was going to win, and the only question was when. And there is something else I want you to consider, because I think it is the under-discussed angle in all of this. The husband. Y'all keep treating this case like it is Cardi versus Tasha, but read these documents and you will see that the legal exposure is shifting toward the husband in a way that should make him very, very nervous. He is the one whose deposition testimony allegedly contradicts his own tax returns. He is the one who allegedly admitted under oath that the asset moves were made to frustrate collection. He is the one named as the controlling figure in Yellen Entertainment. He is the one whose ownership story relies on a brother who has produced no paperwork. If the constructive trust comes down, it is not just over her assets. It is over their joint and individual assets, because the filing explicitly treats him as a successor, a continuation, a co-conspirator in the asset-shifting strategy. He stepped into the line of fire when he allegedly helped his wife move things around, and federal judges do not extend marital sympathy to people who hop in front of their spouse's bullet on purpose. He is not a bystander in this case. He is a co-pilot. And he might be the one whose plane goes down first. Now I want to step back and zoom out, because every once in a while in celebrity legal drama, a case comes along that is going to be cited in textbooks for years. This is one of them. Because the legal theories being stacked here, fraudulent conveyance, continuation liability, veil piercing, constructive trust, permanent injunction, contempt risk, are not exotic. They exist. They are old. They are taught in every law school. But the way they are being assembled and aimed at a single defendant family is the kind of thing that future law students are going to study to understand how a creditor uses every tool in the box at once. And the lesson is going to be the same lesson it has always been. Do not, under any circumstances, mess with a federal court's authority by openly admitting on the record that you are trying to dodge a judgment. The judges in that system are not impressed by your podcast numbers. They are not impressed by your follower count. They are not impressed by the fact that you cried on Instagram Live. They care about one thing. Was a debt established? Yes. Is the debtor playing games? Apparently so. Then we have a problem, and the problem ends when the creditor is paid. I want to talk for a second about the IRS angle, because some of y'all in the comments are going to bring it up and I want us to be smart about it. If the husband's tax returns really do show him as 100% owner, while his sworn testimony says his brother owns 50%, the IRS could potentially have an interest in that contradiction, separate and apart from this lawsuit. If the brother truly owns 50%, then 50% of the company's income should have been allocated to him for tax purposes. If that did not happen, the question becomes, who actually paid taxes on what, and was the right party taxed on the right share? The IRS doesn't care about your gossip. The IRS doesn't care about your blogs. The IRS cares about whether returns are consistent and accurate. And when an inconsistency this glaring shows up in a publicly filed federal lawsuit, you can bet there are tax attorneys somewhere reading it twice and making a mental note. It might not turn into anything. It often doesn't. But the door is now visible. Whether anyone walks through it is another matter. There is also the question of what happens to Tasha K's actual content business going forward. Because here is a thing nobody is discussing. If a constructive trust is imposed, and every dollar of her future income belongs to Cardi B until the debt is paid, what is her incentive to keep grinding? She would essentially be working for free, with a court-supervised allowance, until that $7 million number melts to zero. People in that position often shrink their businesses, go underground, try to operate in cash, try to barter their way around the system. And the second they do that, they are violating the very court orders that are keeping them out of contempt. So the choices in front of her, if this filing goes the way Cardi's lawyers want, are narrow and they are ugly. Keep operating publicly and watch every dollar flow to your opponent. Or try to hide income and risk additional federal exposure on top of what is already there. Neither path is fun. Neither path is sustainable. And neither path ends with the $7 million paid off quickly. Some of you in the comments are going to say, but wait, Tasha, are you sure the judge will grant all of this? And the honest answer is, no, of course not. No filing wins every remedy it requests. Lawyers ask for everything because that is their job, and judges grant the appropriate subset. But what is unusual about this filing is the strength of the underlying record. When the defending party's own husband has, allegedly, on the record, in sworn testimony, said the assets were moved to frustrate collection, the judge is not starting from a position of skepticism. The judge is starting from a position of, my goodness, I have been warning you not to do this for a year, and you went ahead and did it anyway, and then you confessed to doing it under oath. That posture does not lead to leniency. That posture leads to the judge granting the heavy remedies, because the only way to send a message that the court's authority cannot be openly mocked is to grant the heavy remedies. So even if Cardi B does not get the absolute maximum, the floor of what she is likely to get is still catastrophic for Tasha K's financial life. Let me also break down what this means in terms of the broader content creator ecosystem, because I think there is a lesson in this entire saga that applies to every single person who has ever sat behind a microphone, ever opened a ring light, ever posted a hot take that touched a real person's name. The internet treats lawsuits like fiction. Lawsuits are not fiction. They are real. They have real timelines. They have real depositions. They have real bank accounts on the other end. And when a creator finds themselves on the wrong side of a verdict, the consequences do not end with a dramatic Instagram caption and a self-aware podcast episode about lessons learned. The consequences keep coming. For years. Sometimes for decades. Because judgments accrue interest. Judgments can be renewed. Judgments can be domesticated in other states. Judgments can be enforced against retirement accounts in certain situations. Judgments can outlive careers. The cost of a single piece of viral content, made carelessly, can be a financial life sentence. And the speed at which the internet rewards spicy takes makes it very easy to forget that on the other side of every claim there is a person with lawyers and patience and a long memory. You do not have to like Cardi B to recognize what this case is teaching us. You do not have to like Tasha K to recognize that the choices made over the last several years, allegedly, have created a legal situation that is going to define the next several years of her life. The lesson is content agnostic. The lesson is, words are real, the law is real, and the bill always comes. Let me close with the human note, because I think we owe it to ourselves to be honest about this. Years ago, when this beef was younger and smaller and not yet wrapped up in federal filings, Cardi B publicly floated the idea of a truce. She said something to the effect of, I want to be at peace, I want to talk to my mother, I want to see if we can move past this. And for a brief moment, it looked like there was a window. A real one. And then, almost immediately, that window slammed shut, and the pattern resumed, and we ended up here. I do not know what was said behind the scenes. I do not know whose lawyers told whom to keep their mouth closed. I do not know if egos got in the way, if pride got in the way, if old wounds reopened. What I do know is that there was, briefly, a different path. And both parties, for whatever reasons, did not take it. And now we are watching the consequences of that road not taken play out on the docket of a federal court, with the entire internet watching, and with one woman's financial future possibly being signed away over the course of a single judicial ruling. There is a lesson in that for all of us. Beefs can be expensive. Public beefs can be ruinous. Public beefs with people who have access to good lawyers and patience can end careers. The smartest move you can ever make, when somebody offers you a truce, is to at least sit at the table and listen. Because the next offer may not come, and the next move may be a federal filing with your name on it. And while we are talking about lessons, let me hit you with one more, because this one is for the entrepreneurs and the small business owners in the audience, and I know you are out there. If you are running a business, especially a content business, a media business, anything where revenue flows through a single charismatic person, you need to make sure your corporate structure is set up correctly from day one. Not from day 500 when somebody serves you with papers. From day one. You need separate bank accounts. You need real operating agreements. You need actual board minutes if your structure calls for them. You need clean lines between personal expenses and business expenses. You need to actually pay yourself a documented salary instead of treating the company account like an ATM. You need an accountant. You need a tax attorney on retainer for the big decisions. None of that is glamorous. None of that gets you views. But all of that is the wall that protects you when something goes wrong, and if you do not build the wall when the sun is shining, you cannot build the wall in the middle of the storm. The court will look at when your wall was built and what it was made of, and if it sees a wall that was put up the week after a judgment landed on your desk, it will not respect that wall. It will walk right through it. That is the technical legal explanation for why timing is everything in asset protection planning. You plan years in advance, or you do not really plan at all. I also want to address the comments saying, "Tasha, why are you so on Cardi B's side?" Let me be clear. I am not on a side. I am on the side of the documents. I am reporting what the federal filing says, what the alleged sworn testimony reflects, what the judge has already ruled, and what the legal theories on the table actually mean for the people named in them. If the document said something different, I would be reading something different. If the alleged admissions did not exist, this would be a much smaller video. The reason this story is exploding the way it is because the paperwork is brutal, and the alleged confessions on the record are uniquely damaging. That is not a Cardi versus Tasha thing. That is a, what is in the filing, thing. And what is in the filing, is enough to keep a creditor's attorney smiling for years. Listen. I am going to keep reading these documents. I am going to keep tracking the hearings. The next big date on the calendar is going to determine whether the constructive trust gets put in place on a preliminary basis or whether the court waits for a full evidentiary hearing. Either way, I will be back, and I will break it down line by line, the same way I just did tonight, because you deserve the full picture and not just the screenshots. If you got this far, drop a comment and tell me which part of this filing shocked you the most. Was it the dissolved company? Was it the husband's confession on the record? Was it the brother in Mali who allegedly owns half a company he has never produced paperwork for? Was it the constructive trust? Was it the permanent injunction? Was it the fact that the judge warned them in the original trial and they did the exact opposite anyway? Tell me. I read every single comment, and I will be using your reactions to guide the next breakdown. I love y'all. Stay smart. Stay informed. Don't sign anything without reading it. And for the love of everything holy, when a federal judge tells you not to move your assets, do not move your assets. I will catch you on the next one. Bye.